This is a screenshot video for the online crimes course, and in this video we're going to start talking about burdens of proof in a criminal case, the distinction between regular and affirmative defenses, and then we're going to, at some point, I don't know if it'll be in this video, but we'll certainly get to it, talk about specific affirmative defenses in the New York penal law. But first, the general material about burdens of proof. In a criminal case, actually anywhere in the United States, not just in New York State, the prosecution, which in New York is typically referred to as the people of the state of New York, has the burden to establish beyond a reasonable doubt every element of the offense that's charged. And the defendant's commission of the offense. There's Supreme Court cases that state that burden imposed upon the government to establish guilt beyond the reasonable doubt standard is a matter of constitutional obligation under the Due Process Clause of the United States Constitution. And to give you a sense, perhaps, of more specificity as to what reasonable doubt is, I've quoted from a 1897 case from the New York Court of Appeals, and where the court said reasonable doubt is not mere whim, guess, or surmise, but it is such doubt as reasonable men or women may entertain after careful and honest review and consideration of evidence. It must be founded in reason, and it must survive the test of reasoning or mental process of reasonable examination. So if you and I were on a jury in a criminal case, and when we went to retired to deliberate after the proof had been put in front of us, and the judge had instructed us about the law, and the attorneys had given their closing statements, if one of us simply said, in my gut, I don't feel the defendant did it, that's not going to be enough to establish a reasonable doubt. To have a reasonable doubt, one has to, as the Court of Appeals said, come up with some kind of reason for why they've reached the conclusion that the defendant is not guilty. I actually think a classic example, it's a bit of a dated reference now, but I'm thinking of the O.J. Simpson criminal case, where for a reason that doesn't make a lot of sense to me, during trial, the prosecution had Mr. Simpson, the defendant, try on a pair of gloves that the prosecution's theory of the case was that the gloves had been worn by the person who murdered Mr. Simpson's former wife and a person who was her guest at the time. And so Simpson is standing in front of the jury, and it's if you saw this clip, it's embedded in your memory. He's struggling putting on the gloves. And some would think then that the gloves didn't fit. And if you were on that jury, it would seem to me that it would have been a fair analysis to say, the prosecution says that those gloves were worn by the killer, and yet the gloves didn't fit the man the state is telling us is the killer. Or as the great late Johnny Cochran said in his summation on behalf of Mr. Simpson to the jury, if it doesn't fit, you must acquit. That struck me always as a classic example of reasonable doubt. So a question then becomes whether the defendant ever incurs a burden of proof when the defendant asserts a defense at trial. And here we've got to draw a distinction between defenses that are known as affirmative defenses and defenses that are not labeled as affirmative defenses. to kind of keep a parallel set of terms, I'm going to use the term defense is either an affirmative defense or it is a regular defense. In New York State, we never have to puzzle over whether or not a defense is an affirmative defense because the legislature has specifically identified those defenses that it believes should be considered an affirmative defense. And we're going to look at three different affirmative defenses at some point soon, and that is the defenses of insanity, duress, and entrapment. And the deal is, if the defendant is raised an affirmative defense, then if the defendant's going to prevail on that defense, the defendant has to establish the defense by something known as preponderance of the evidence standard. More of that in just a bit. If, however, the defendant has raised what we now can call a regular defense, one would be justification or self-defense, then the defendant has incurred no burden, and in that case, the government is going to have to, the state's going to have to not only prove that beyond a reasonable doubt all of the elements of the crime and that the defendant engaged in those elements, but also the prosecution is going to have to disprove the regular defense by proof beyond a reasonable doubt. Just a little bit more. Some of this in a courtroom is almost housekeeping, but I know that a judge is going to do something like this. If the defendant has raised an affirmative defense, the judge is first going to give the jury instructions on the prosecution's burden to prove guilt beyond a reasonable doubt. And the judge is going to say at that point in his or her charge, if you believe that the government has not established guilt beyond a reasonable doubt, then stop your deliberations and return a verdict of not guilty. On the other hand, the judge will say, if you find that the government has met its burden of beyond a reasonable doubt, you are now to consider whether the defendant has established by a preponderance of the evidence these elements of the affirmative defense, by way of example, entrapment, and then the judge will give the jury the elements and say, if you find that the defendant established these elements by a preponderance of the evidence, then you're going to have to also return a verdict of, not also, but return a verdict of not guilty. So it's kind of wordy, but I think if you give it some thought, it's going to make some sense. What is preponderance of the evidence? Preponderance of the evidence is not as heavy of a burden as beyond a reasonable doubt. The terminology I like to use, and that you'll see courts adopt, is that if I have the preponderance of the evidence burden, I have to establish that it's more likely than not that the facts that I claim existed. And I give you a little synopsis that I just gave you verbally about how that's going to work in the courtroom. Now, what I've done in the postings is I've given you some notes regarding the specific affirmative defenses of insanity and the specific affirmative defense of entrapment. And what I'm going to do is at some point in the next video bring up those notes and we'll talk about it. I didn't give you any notes on duress, but I gave you a newspaper article about a murder case in New Hampshire. And I think if you read that article and think about duress, you might come up with a good example of how it might apply. But what I'm going to do at this point is stop this video, and then I'm going to put the notes up that I have, and we'll talk more about the specific affirmative defenses of insanity, entrapment, and duress.